Hello, let's start today's editorial. Bench and bigotry, a judge's appointment exposes the opaque collegium system. The questionable evolution of Advocate L. Victoria Gowrie as a judge of the Madras High Court epitomizes the problematic nature of the system of judicial appointment. It also portends a government driven project to take over the bench through its favorites. Ms. Gowrie, whose unbased prejudice against minorities became evident when her past speeches and interviews came to light after her name was approved by the Supreme Court, was sworn at an oath taking ceremony organized with great dispatch. Earlier, the Union Law Minister had received the recommendations concerning a set of candidates with extraordinary speed not displayed in other cases. It was clear that the government wanted to act ahead of any possible interim order from the court, which had agreed to hear petitions from a group of lawyers against her appointment. In the process, the government ignored a specific recommendation that R. John Sutton, an advocate whose candidature was earlier opposed by the minister, by appointed first. It is a clear message that the present regime would pick and choose among those approved by the collegium. In a matter informed by its political preferences, the government repeatedly has its own indicates that the conflict over the appointment process has reached a stage in which the collegium is consistently under pressure to yield to the executive's position or on individuals if any meaningful progress is to be made on the perennial process of filling up vacancies. The challenge to Ms. Gowrie's appointment was on the ground that had there been effective consultation and relevant information placed before the collegium, her appointment may not have materialized further by her speech denouncing Christians and Muslims. She had rendered herself ineligible to act without fear or favor, and that she could be expected to dispense justice without discrimination on the ground of religion. However, the bench rightly rejected the petitions, observing that it cannot revisit the suitability of any appointee after the collegium had decided on it. The government on the judicial side could not possibly have gone on into a choice made by its top three judges. Indeed, it made no sense to refer the collegium's decision to a bench for review. It is apparent that the state government too had not flagged her extreme views. While political affiliation should not disqualify anyone from judicial office, open bigotry or to it is also a signal failure of the collegium process that a controversial proposal could get past its scrutiny. What is needed is more than reform in the appointment system, perhaps a process that combines an objective evaluation of the candidate's credentials with an independent mechanism that ensure public scrutiny of the suitability. What is in place at present is an opaque, closed door consensus building that could leave room for unhealthy compromises. Thank you very much. Let me know your response on the comment section. Thank you very much.